Today I'll be talking to you about the administrative relation between the Union and the states, Article 245 to 263. My name is Aditya Krishna Malhotra and my roll number is 62. The introduction. India follows a quasi-federal system. The states are not sovereign, as in they are not completely independent. They have someone that is over them, and that is the Union. The Union is stronger to maintain national unity, and the federal structure adapted to the Indian conditions. India being so diverse, India having such a large population, India having so many languages, so many different people, we needed a federal structure. Although it is not completely federal, it is federal in structure and unitary in spirit. The federal nature of India, dual government, we have the union government, that is the center, and we have the states. There is a clear division of powers in the 7th schedule, in that we can see the union list, the concurrent list, as well as the state list. When we talk about the union list, it is greater than the concurrent list, and the concurrent list is greater than the state list. Next up, we'll talk about the constitution. India has a written and a supreme constitution, as you can see here. And we have an independent judiciary. And this independent judiciary, the third pillar of democracy, protects the constitution. When we talk about the unitary features, things like the single citizenship, the single constitution for the center and the states, that is, the states do not have their own separate constitution, and things like the integrated judicial system. The emergency provisions strengthen the center. As you know, during the times of emergency, the union gains a lot more powers compared to the states. The union can form laws in the state. The union can have complete control about all of the things that are of major importance. The administrative relations, this is the main topic that I'll be talking about. The relations operate under normal conditions differently, under emergency conditions differently, and the union can issue directions to the states. States must not hinder the union executive power. When it says the union can issue direction to the state, it means that if the union has made a law, and the state has made a law, and the state law is something that is in contravention or is opposite to something of the union can issue direction to the state. Or if the union has made a law and the state is supposed to implement it and the state is not implementing it, then the union can tell the state to implement a certain thing. The states must not hinder the union executive power. So the executive power of the union is supreme as compared to the state's executive power. The center-state relations, there are three types: the legislative relations, the administrative relations, and the financial relations, 1, 2, and 3. These are governed mainly by Part 11 of the Constitution. Please don't read this as Part Xi of the Constitution, like Xi Jinping. Not to mention the Doordarshan thing that happened that got a reporter fired. The legislative relations, Article 245 to 255. There are three lists, as I told you: the union list, the state list, and the concurrent list. 1, 2, and then 3. Union, then concurrent, then state. The union law prevails in case of a conflict between the union and the state list. The administrative relations, the states must comply with the union laws. That's compulsory, as I told you. The IAS and the IPS under the union control. That means the Indian Administrative Service as well as the Indian Police Service are under the union control. That is why even in a state like Goa, you see Kumars and Malhotras and Srivastavs in high positions. The center coordinates interstate matters. So here the center can coordinate the interstate matters using the IAS and the IPS, and this is part of the administrative relations. The union can assume greater control in emergencies, as I have told you earlier. Article 246 and Article 250. These two articles talk about this greatly. I'll deal with them in another video. The financial relations, these are very simple. Article 268 to 293. The distribution of tax revenue, the grants in aid to the states, and the borrowing power regulated by the union. I'll make a completely different video about the financial relations, but basically you need to know that out of the total tax that the government, the center, collects from the different states, from the different citizens, the direct tax, the indirect tax, all of that combined, a large portion goes completely back to the states. So the states can actually perform their own functions. Next, the administrative relations among the union, the state, and the local bodies. When you talk about local bodies, there are two things here. It is the panchayat as well as the municipality. So the Panchayat Raj Act is still something that we are governed by. The constitutional framework, the Article 256 to 263, the mechanism of coordination and control between them, the Panchayat Raj and the urban local governance structure. So this includes things like the municipalities, and we have corporators. Recently, the Maharashtra election took place. Chapter 2, the administrative relations. 10 articles that I'll be talking about. Article 256 tells us about the obligation of the states and the union. Article 257 tells about the control of the union over the states in certain cases. Article 257A talks about the assistance to the states by deployment of armed forces or other forces of the union. Article 258 talks about the power of the states to entrust the functions to the union. Article 259 talks about the armed forces in states in Part B of the first schedule. Article 260 talks about the jurisdiction of the union in relation to the territories outside India. Article 261 talks about the public acts, records, and judicial proceedings. Article 262 talks about the adjudication of disputes relating to waters of interstate rivers or river valleys. And Article 263 talks about the provisions with respect to an interstate council. So in the interstate council, we have the prime minister, we have the chief ministers, we have the chief minister of the union territories. There are 5 union territories which have chief ministers. The adjudication of disputes relating to water of interstate rivers or river valleys. Interstate rivers, 2 states which share a river are called riparian states. For this, there is a tribunal. There's a act from 1956, the Water Tribunals Act of 1956, which talks about the tribunal being formed whenever there is a dispute, and whatever is the decision of the tribunal will be the final decision. Next, the meaning and the objective. Administrative relations are the mechanisms for cooperation and coordination among the union, the state, and the local bodies. This ensures smooth administration of laws, efficient governance, and peace and order in the entire country. This balances the distribution of power in a quasi-federal Indian system. If we had just the administration done by people that are elected by the union, this would not be fair to the states. And if we had something by only the states, the coordination between the states and the union would not be really good. This aims to prevent the administrative conflicts and secure effective policy implementation. The union makes a law, state can implement it because officers appointed by the union are part of the state administration. And these people that are there in the state, a happy person because he's a high post person. He's like, hi guys, like and subscribe this video. He is telling you about how effective policy implementation is possible. The constitutional basis, the union state administrative relations, Article 256 to 63, 256 and 257 talk about the directions by union to the states. When there is a law made, if the state is not applying it, what they're supposed to do, they're supposed to apply it, how they're supposed to apply it. All of these directions can be given by the union to the states. Article 258 and 258A, delegation of the functions. Article 262, the interstate water disputes, as I told you. Article 263, the interstate council. Who is part of this? The PM, the different chief ministers of union territories. Whoever has to be spoken about is part of the interstate council. Miscellaneous provisions 260 and 261. So the center's direction to the states. Article 56, state must execute union laws and follow directions from the union. Article 257, the state executive powers must not impede the union executive functions. The union can direct the states on communication means of national and military importance and railway protection within the state. If there are extra costs incurred by the states, the union reimburses or appoints an arbitrator. That means if state has done something for the union and state has spent money on it, so this money will be paid back, reimbursed to the state by the union. If there is a conflict between the state and the union about how much money should be given, then they can appoint an arbitrator. The delegation of administrative functions, Article 258, the parliament may entrust the union functions to a state with consent. The parliament can use state machinery to enforce the union laws. Article 258A, a state can entrust its function to the union government with consent. This ensures flexibility in governance and better use of resources. Now, my favorite topic, the All India Services and Center State Coordination. Manoj Kumar, IPS, as well as Sattu. The All India Services and Center State Coordination, Article 312. The Parliament empowered to create an All India Services, example IAS and IPS. This helps coordinate the administration across the union and the states. The officers are appointed nationally, but serve both levels for uniform policy implementation. They serve both levels, as in the state as well as the union. These services ensure the unified bureaucratic standards. Bureaucracy is very important for smooth governance in a country. Grants and Interstate Council. Grants in Aid, Article 275. Parliament may provide financial assistance to the states, often with conditions. You need to do this, and then we can give you this amount of money if you're willing to do these things. Encourages cooperation with development schemes. The Interstate Councils, Article 263, the consultative body for the center and the states to resolve disputes and coordinate policies. The Interstate Council, what is it? It's a consultative body for the center and the state to resolve disputes and coordinate policies. Meets regularly and decided by consensus, so by an agreement by all of the people. There are 4 case laws that I'll be covering here, and then I'll do the analysis and the conclusion. So the first case law, this is the citation AIR 1964 SC 648. The Supreme Court in Jayantilal Amritlal versus F.N. Rana, here it was distinguished between the functions exercisable by the President on behalf of the Union and the functions conferred upon the President under the express provision of the Constitution only. The former functions can be delegated under Article 258(1) and not the latter functions. It must also be noted that only executive functions can be delegated under Clause 1 of the Article 258 and not any quasi-judicial function. Case Law 2. In Shamsher Singh versus the State of Punjab, citation AIR 1974 SC 20192, it was clarified data distinction made by the Supreme Court in the previous case between the executive functions of the Union and the executive function of the President does not lead to the conclusion that the President is not the constitutional head of the government. He still is. Moreover, all the functions exercised by the President are to be exercised with the aid and advice of the Council of Ministers. Whatever the President does, he will do it on the aid and advice of the Council of Ministers and the Prime Minister. Article 74(1) speaks about this exactly. The Case Law 3. T.N. Kovri Sangan versus Union of India. AIR 1990 SC 1316. Here it was held that if the central government failed to make reference of disputes, the court under Article 32 issues mandamus to central government to carry out the statutory obligations. Case Law 4. The State of Andhra Pradesh versus the State of Karnataka. AIR 2001 SC 1560. The Supreme Court held a dispute between riparian states. As I told you earlier, riparian states are states where the 2 states share a water body in the middle. The Supreme Court held a dispute between riparian states located in the interstate river basin relating to non-implementation of binding decision of the water tribunal. As I told you, a decision by the tribunal is binding, constituted under the Inter-Water Dispute using 2C of the Interstate River Water Dispute Act of 1956. Similarly held in the state of Haryana versus the state of Punjab, AIR 2002 SC 585, relating to the river Kaveri. Next up, the analysis. Indian Constitution balances the unity and the diversity. It is federal in structure and unitary in spirit. It's best described as a quasi-federal system. The strong center ensures stability in the country and coordination between the state and the union. Finally, the conclusion. The administrative relations ensure coordination and cooperation among all levels of government. That is the state level, the union level, as well as the local bodies, which include the panchayat as well as the municipalities. The Constitution provides directions, delegation, dispute resolution, all India services, and financial aid methods. The 73rd and 74th Amendments strengthen the rural and the urban local governance with the constitutional status. Reflects India's quasi-federal model where the union, the states and the local bodies must work collaboratively. Thank you so much for watching, guys. If you enjoyed this video, like and subscribe this video. My biggest inspiration in life is Mr. Yadav Yadav YG Law, and I'm trying to make a channel just like him. So like and subscribe and comment I love YG Law if you love YG Law.